I have been meaning to do this vlog since
last year.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie, and I've been meaning to do this vlog literally since last year. Of course, it's only January 4, 2022, so that is a lame dad joke, but I want to break down the most recent decision coming out of the Project Veritas versus the New York Times defamation lawsuit. Now, for those of you who may not know what is going on in the Project Veritas versus the New York Times defamation lawsuit, first of all, welcome to the channel because you must be new here. I have been covering it from the very beginning. Project Veritas is suing the New York Times for defamation for a piece the New York Times ran about Project Veritas, accusing them of spreading disinformation, embarking on a coordinated misinformation campaign about a story they ran a while back during the election season, alleging certain ballot harvesting improprieties which were apparently against the law, that the New York Times said was not against the law, which were in fact against the law. But I won't go over that. I'll just refer you to the vlog here, now, somewhere.
Here.
In their hit piece, the New York Times accused Project Veritas of having embarked on a coordinated disinformation campaign, which is quite rich and ironic coming from the New York Times, given that's exactly what they did as relates to this piece on Project Veritas. Project Veritas sued the New York Times for defamation. The New York Times sought to have the lawsuit dismissed on a number of bases, including anti-SLAPP legislation. The New York Times motion to dismiss the lawsuit was itself dismissed. They appealed the dismissal of their motion to dismiss the lawsuit, and in the interim petitioned the court to stay depositions pending the outcome of the appeal of the dismissal of their motion to dismiss. The New York Times sought and obtained a stay of depositions in their lawsuit pending the outcome of their appeal of the dismissal. Why is that relevant? Well, in the interim, somehow they obtained solicitor-client memos between Project Veritas and their attorneys,
and they actually published those memos.
The New York Times went on to publish solicitor-client privileged memos between Project Veritas and their attorneys, memos which by all accounts they only inappropriately obtained because of a raid on James O'Keefe and two other former journalists at Project Veritas by the FBI, and the FBI apparently leaked the information seized from the cell phones of James O'Keefe and other journalists from Project Veritas to the New York Times, that the New York Times then subsequently punished, retracted, apologized for, but ultimately published. And this brings us back full circle to the Project Veritas versus the New York Times defamation lawsuit, wherein Project Veritas has sought an order from the court enjoining the New York Times from publishing solicitor-client privileged memos that they unlawfully or inappropriately obtained, and ordering them to destroy and delete any and all copies they have in their possession. And lo and behold, Project Veritas actually succeeded on this claim, and the judgment itself is very, very interesting to read. Supreme Court of the State of New York, County of Westchester, Project Veritas plaintiff against the New York Times Company, Maggie Astor, Tiffany Shue, and John Doe's 1 through 5 defendants. And the nature of the motions before the court that the court is adjudicating on: New York State Court's electric filing, NYSCEF, document numbers 170 to 195, were read in connection with the instant motion brought by order to show cause by Project Veritas, pursuant to CPLR 3103, against the defendants, seeking an order directing the defendant, the New York Times Company, the Times, 1. To remove all references to or descriptions of Project Veritas's attorney-client privilege information published on the Times website on November 11, 2021. 2. To return or immediately destroy all copies of Project Veritas attorney-client privilege materials in the Times possession. 3. To refrain from further publishing Veritas attorney-client privilege materials. 4. To order the Times to cease further efforts to solicit and acquire Veritas's attorney-client privilege materials. And 5. For an interim order directing the Times to sequester and refrain from further publishing any of Project Veritas's attorney-client privileged materials. The court then goes on to briefly describe the underlying fact pattern, which I've gone into in some detail, but for the sake of it, don't trust me, this is what the court has to say about it. This latest chapter between these parties began on November 11, 2021 at 1:07 p.m. when the Times emailed Project Veritas founder James O'Keefe and Project Veritas's outside counsel, Benjamin Barr, stating, quote, "We are planning to publish a story based on legal memos that Mr. Barr provided to Project Veritas. The memos provide legal advice about how different PV operations could violate various laws, including the Espionage Act and Section 1001. The memos give guidance about how PV can remain, in Mr. Barr's view, on the right side of these laws," end quote. The email asked for comment on the forthcoming story by 5 p.m. Without waiting until the stated time, at or before 3:02 p.m. Eastern Time, the Times published on its website full copies of the privileged legal memoranda prepared by Mr. Barr for Project Veritas. Setting aside the legal and ethical questions of having somehow obtained literal solicitor-client privileged memos between a client and their counsel, can you imagine being the New York Times and thinking somehow that asking your attorney how you can conduct your business while remaining within the confines of the law
is somehow incriminating?
"On y soit qui mal y pense," the New York Times. You have to be a special level of sick. You have to engage in a special level of confession through projection to think that someone asking their attorney how they can ensure that their behavior is compliant with the law is somehow evidence of guilt. But I digress. Let's actually get into the legal question as to how the New York Times somehow misappropriated literal solicitor-client privilege memos between a client and their attorney and the lawfulness of having published those solicitor-client privilege memos. Project Veritas seeks relief pursuant to CPLR 3103C. CPLR 3103C provides, in relevant part, quote, "If any disclosure under this article has been improperly or irregularly obtained so that a substantial right of a party is prejudiced, the court, on motion, may make an appropriate order, including an order that the information be suppressed," end quote. Now, this court order is going to hinge on the concept of improperly or irregularly obtained memos, and I would have liked to have seen the court elaborate a little more on how it was that the New York Times actually obtained these solicitor-client privilege memos, whether or not it was the FBI that leaked them to them. The bottom line is that there is no proper or regular way the New York Times could have obtained these solicitor-client privilege memos, but for the fact if Project Veritas ever gave them to them. And just in case that description was a little unnecessarily complicated, just appreciate this. Bottom line, there is literally no regular or proper way the New York Times could have obtained solicitor-client privilege memos unless Project Veritas gave them to them, a court ordered it to be given to them, or it was done by accident by Project Veritas. Project Veritas claims that the Times' intrusion upon its protected attorney-client relationship is an affront to the sanctity of the attorney-client privilege and the integrity of the judicial process that demands this court's intervention. According to Project Veritas, it seeks only a narrow protective order to limit the Times from, quote, "improperly or irregularly obtaining," end quote, and disseminating the privileged communications of its litigation adversary. Project Veritas argues that, quote, "a decision denying this protective order, particularly in today's internet and social media age, will permit any would-be citizen journalist, blogger, or Instagram influencer to claim the right to publish their litigation adversary's attorney-client privilege communication with impunity."
That is not and cannot be the law, end quote.
So just appreciate this nuance here because it's absolutely critical. It's not just that the New York Times is publishing a solicitor-client privilege memo of just about anybody. They are publishing a solicitor-client privilege memo about a party that is currently suing them, a memo that talks about the substance of that lawsuit in the context of a lawsuit where they sought and obtained a stay of depositions. The New York Times sought and ultimately obtained an order of the court that basically muzzled the parties in the context of a lawsuit wherein they somehow unlawfully or improperly obtained solicitor-client privilege memos that they went on to publish, notwithstanding the fact that they asked the court to stay the deposition in that file. That is literally, metaphorically, like asking the court to tie your adversary's hands behind their back so that you can continue to punch them in the gut. And yes, I appreciate that using the terms literal and metaphorical in the same sentence is quite literally a Madawian paradox. But getting back to the court order, this is what the judge has to say about the solicitor-client privilege memos. Here, Project Veritas has established that it is the owner of the memoranda and the privilege, and it is not disputed that it did not waive its privilege. Since no discovery was exchanged, this is not a case where the documents were inadvertently turned over during discovery. Project Veritas has alleged that the Times knew that the individual that provided the memoranda was not authorized to disclose them. There is nothing in the record to show how the Times obtained the privileged memoranda that belonged to Project Veritas. That information is solely within the Times' knowledge and possession, and it has not offered any explanation beyond vaguely stating that the memoranda were obtained through its, quote, news-gathering efforts, end quote. However, in its memorandum in opposition, while attempting to distinguish the facts of the case of Rose v. Levine from this case, the Times incredibly admitted that here, quote, no apparent bribery was used to obtain the memoranda, end quote. The court finds that Project Veritas has met its burden of showing that the subject memoranda were obtained by irregular means, if not both irregular and improper means. The court then goes over the history, the importance, the sanctity of the solicitor-client privilege, which I don't think many people need to be reminded of, and if you do need to be reminded of that, you probably work for the New York Times. The protections afforded by the attorney-client privilege have not only developed through over 4 centuries of common law, but are found in statute, the Code of Professional Responsibility, and are strongly rooted in the constitutional right to counsel. The attorney-client privilege applies to confidential communications between clients and their attorneys made, quote, in the course of professional employment, end quote. The communication itself must be, quote, for the purpose of facilitating the rendition of legal advice or services in the course of a professional relationship, end quote. The New York Times then goes on to argue case law that it believes supports its position. Previous cases in which a court allowed the publication of certain privileged information on the grounds that it was properly obtained and of public concern, and the judge in this case says, well, that is easily distinguishable from the case at hand. However, Nicholson is readily distinguishable from the case at bar. First, Justice Scroy made a factual finding that the 2 media interveners did not obtain the document at issue illegally or by improper means. In fact, in Nicholson, a party had actually leaked the document. Therefore, the court declined to issue an injunction against the 2 media outlets, but did issue one against the party. Finally, the documents were of public concern as they relate related to a significant environmental contamination. The New York Times then goes on to argue that the solicitor-client privileged memos in this particular case are in fact of public concern, basically arguing that what a client asks of their attorney is of public concern, to which the court says, no way.
You shall not pass!
A client seeking advice from its counsel simply cannot be a subject of general interest and of value and concern to the public. It is not the public's business to be privy to the legal advice that this plaintiff or any other client receives from its counsel. Like a public employee who brings a First Amendment claim alleging a prior restraint on her freedom of speech must show that the speech touches on a matter of public concern, it is quintessentially personal, not public in nature. The court, rightly in my opinion, goes on to conclude that the solicitor-client privilege memo are not of public concern, and therefore the balance tips in favor of protecting that privilege. The New York Times then goes on to shift the argument to one of prior restraint, to which the court also says no go. Here, the court's protective order does not act as an impermissible prior restraint on the Times. As important as the First Amendment's protection against prior restraints is, on the present facts, the erosion of the attorney-client privilege is a far more imminent concern. Quote, what is also at stake in the dissemination of privileged information into the public domain is the privacy of the individuals mentioned or discussed therein and the importance of full and free communication between attorney and client. Quote, hit and run, end quote, journalism is no more protected under the First Amendment than speeding on a crowded sidewalk is permitted under a valid driver's license, end quote. Greenberg versus CBS Inc. Now, full disclosure, although this should not come as a surprise to anybody who has been around the channel for longer than a week or so, I do not like the New York Times. I do not trust the New York Times. I think they are dishonest, disingenuous, and I dare say even dangerous. So with that said, if you want to discredit my opinion of this decision, go ahead and do so, but I think this judge gets it. I think that this judge gets it, this judge got it, and this judge granted Project Veritas' motion, and these are the orders that the judge issued, or at least some of the most relevant ones. Accordingly, based upon the stated reasons, it is hereby ordered that the plaintiff Project Veritas' motion is granted in part to the extent set forth below, and it is further ordered that the defendant New York Times and its agents, employees, legal counsel, or other persons under its control are directed to immediately turn over to plaintiff Project Veritas' counsel all physical copies of the subject legal memoranda prepared by Project Veritas' counsel, Benjamin Barr, that are in its control or possession. And it is further ordered that the defendant New York Times and its agents, employees, legal counsel, or other persons under its control are directed to immediately delete, destroy copies of the legal memoranda prepared by Project Veritas' counsel, Benjamin Barr, from any computer, cloud server, or other data collecting or disseminating sources, including but not limited to all attachments to emails and cloud server devices, and to remove such documents from the internet and any websites or servers over which they have control. And it goes on, but I think you get the idea. Project Veritas has won on this particular motion, at least for the time being, and I know there's a lot of people out there who are going to be asking themselves, how can one evidence destruction of these documents? What are the chances they don't somehow, somewhere, keep copies of these legal memoranda, and or the damage is already done? They have been published. People already know what they have to say. So the New York Times has already gotten an insight into Project Veritas' litigation process. Fine. We can't undo what has been done. And as far as the sanction goes, the court orders the following. Ordered that in the event the defendant New York Times fails to comply as directed herein, Project Veritas shall upload it to the NYS CEF file no later than January 28, 2022. Upon notice to defendants, an affidavit affirmation of non-compliance, and plaintiff is granted leave to seek any relief related thereto, including preclusion, striking of pleadings, and costs and or sanctions. We will see what happens. Some out there are going to say too little too late. Justice after an injustice is still an injustice. Fine, so be it, but at the very least, Project Veritas has gotten another W for the time being, and we will be following to see what happens, because I am interested to see if the New York Times complies, or if it doesn't, and if it doesn't, what Project Veritas is going to do. One thing is for certain, if and when there are any updates, I will provide it to you, but if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below, because it feeds the algorithm.
Doctor, out.
If you want to support the channel, all of the support links are in the pinned comment. We've got some great merch and some new merch. Robert Barnes and I do weekly live streams every Sunday. We do weekly streams with the guest every Wednesday called The Sidebar. If you want to find us and support us on Locals, where supporters get lots of exclusive content, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, so you can catch it there, but more important than anything, take care of yourselves, check in on friends and family, make sure everyone around you is doing well. Happy New Year, and may 2022 be a little better than 2021. And with that said, now you know your vlog. Peace out.